The pre-trial review is in the matter of CFI 005-2021 before Justice Lord Angus Glennie and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimants are represented by Nimble Legal Consulting FZE and the lead counsel is Justina Stewart. The defendant is represented by Curtis Mallet Prevost, Colt and Mosley LLP. Lead counsel is Sophia Hurst. Thank you very much.
Thank you. Who wants to go first? Claimant, I suppose.
Just by way of housekeeping, may I ask what your lordship has had the opportunity to read out of the large?
I've read quite a lot. Some of it fairly quickly. I've touched upon most of the stuff that's been mentioned in the skeleton arguments.
Okay, good.
I'm not going to promise that I've read everything in minute detail.
Okay, and of course you've read the skeleton arguments, so great. It seems I would suggest,
I've deliberately not read the stuff that came in this morning. It seemed to be, I wasn't sure to what extent it had been copied to the other parties. It didn't say so. And therefore I wasn't going to read anything that was sent to me privately.
As far as
it may have been sent to the other party, but there's a letter.
I'm not sure what that is, my lord, so it's certainly not something I'm intending to refer to. I don't know.
There's a letter from one side complaining about the conduct of the other.
I think it was in response to complaints made against those instructing me by Curtis, and I think it would have been a letter or an email which basically said they were wrong.
Right. Anyway, I haven't read it deliberately. I don't think this is the right forum in which to vent grievances about the behaviour of the other parties.
Quite.
I doubt it's something that we need to trouble your lordship with.
Yeah. Right.
Right.
What do you want to do? There's three things to deal with, really, aren't there? The non-controversial thing is when we're going to have this third day or however long we need. Then there's the two applications. So what do you want to deal with first?
In terms of trial timetable, I can see from my learned friend Skeleton that it seems that she's only available from the 24th of October. I'm not sure, Ms. Hurst, if that's correct.
That's correct, my lord. I'm afraid after this trial I am in some difficulty. I'm completely away for 3 weeks and then I'm under brief for another trial until the 3rd of November. So adding a third day is tricky. It's impossible up till the 24th of October and it's tricky thereafter for me, I'm afraid.
What do you suggest we do? We don't have a third day?
I mean, I don't know what the court's availability is in early November, if that's possible. Another option might be to relist the 3 days together slightly later, although the defendant's preference, and I'm sure the claimant's as well, is not to push this back. I think both parties want to get on.
Right. What's your position, Ms. Stewart?
It's the first time it's been suggested that we could perhaps have all 3 days later. I can see that having all 3 days in one go might be more effective from a cost perspective. Might I just take instructions on that?
Well, let me just, before you take instructions, I could tell you that subject to things that I don't know about on this diary, I could do the week of the 7th of November.
And my lord, that would be either for one extra day or for the full 3 days.
And I must say I'm dubious about whether 3 days is enough, given the lack of goodwill between parties. I'm not pinning blame on any particular party. Just it doesn't seem to me that we've got to that this action is being conducted with the full cooperation that normally is expected of actions in the DIFC. But I don't want anyone to come back on that to start another argument.
No, my lord. Can I make a suggestion?
Yes.
Which is that both of us have got instructing list solicitors behind us. If we, in light of your lordship's indication, find out availability of the parties and the witnesses for that week, either for an extra day or for 3 days or 4 even, while we're on the call, if possible, and perhaps we proceed to deal with other matters and come back to timetabling when we've got a better idea of the parties' availability, that might be most efficient.
Check the week of the 14th as well, as far as I'm concerned.
Yeah, it's looking good for us.
Right, well, you may want to check with witnesses and so on.
Yeah, we're going to check, yeah.
And as to whether you want to keep the 2 days and then add 1 or 2 more, or whether you want to have a block of 3 or 4 days. Anyway, let's come back to that. We'll come back to that at the end. Yeah, so do you want to run your application, Monsieur?
Yes, there is just one other point, which is in relation to Mr. Baldraldin. I discovered in my learned friend's skeleton that Mr. Baldraldin won't be called. I don't know whether it's therefore the intention of the defendant to withdraw Mr. Baldraldin's statement, as they indicated they would do.
Of course, that follows, my lord. We don't rely on his evidence in light of your lordship's ruling and his unavailability. And I understand we're seeking to relist the trial, but in the circumstances, I won't push to accommodate Mr. Baldraldin. We'll withdraw his evidence.
Thank you.
That is even if the trial is moved to a different date. But you can always make an application to adduce it once we know what date it is and whether he's available.
My lord, yes. It's been somewhat difficult to confirm Mr. Baldraldin's availability, hence the late indication at this PTR, and I do apologise to my learned friend for that. I very much doubt I'll be in a position today to indicate whether we would seek to rely on his evidence at an adjourned trial. I think your lordship gave liberty to apply in the final paragraph of your lordship's 14th of July order. So if necessary, I will make an application, but my instructions are that that's unlikely. I can't do any better, I'm afraid, my lord, at the present time.
We can record at the moment that his witness statement is withdrawn, and then it's up to you if you want to relist it to make an application to the court at the appropriate time.
I'm grateful for that, my lord.
Very well, thank you.
Right. It would probably make sense, I'd suggest, to consider the claimant's application first. And I'm going to try and be as succinct as possible, as uncontentious as possible. In essence, the application really just seeks to address the changes in both parties' cases as disclosed by the trial witness statements. And by trial witness statements today, what I mean is those statements that were served and filed on the 7th and the 27th of June. Before going on to the crux of the application, I really just want to flag a few points. We acknowledge that the statement of case provided by the claimant's previous legal team is poor. There's no two ways about it. We also appreciate that the seeking to rely on a witness statement as a statement of case is also a less orthodox approach. However, I would say that going back to the state of our statements of case, to us there seemed little point in amending until we understood the defendant's case, and that was why we made the requests for further information. The defendant declined to answer the requests. We had to make the Part 19 application, which the registrar in large part granted. However, we only received those responses at the same time as the first round of the witness statement, at which stage it then became clear to us that the defendant's case had changed in some key respects. So the natural thing to do would have been for the defendant to amend her amended defence and counterclaim, and then we would follow. Defendant declined to do that, which brings us to where we are today. Now, I'd suggest that in relation to our application, there are 4 questions. First of all, if the defendant has changed her case via the trial witness statements, and in particular, Miss Burke's 6th witness statement, is she entitled to do that without amending her amended defence and counterclaim, which I'm going to refer to as ADC. If both the next question is, if both the defendant's and the claimant's case has changed, if the pleadings are to be amended, is it consistent with the overriding objective for the defendant to amend her ADC first, or for the claimants to amend their reply and defence to counterclaim, and then for the defendant to amend her ADC so that the claimants can then re-amend their reply and defence to counterclaim? I'd suggest that surely the answer is obvious. It would be the former is more consistent with the overriding objective. Then we get to the question of, has the defendant in fact changed her case? Defendant says no. We simply don't understand that position. And then the next point, and the final point, if the defendant has changed her case, should her amended case, meaning that case which is inconsistent with the pleaded case, be struck out? That would require a detailed analysis and strikeout of part of the defendant's trial witness statements. Or should one of the options of the type set out in the claimant's application be adopted?
Mm-hmm.
Now, turning to the first question, is the defendant...
Before we go to that, there's clearly a dispute between you as to whether the defendant has changed her case.
Yes, I'm going to get on to that.
But I'm not going to resolve that on a PTR. If you want to strike out someone's case, then that's an application to be made,
Right.
not a PTR review matter. It seems to me that the right approach, one possible approach, is for the court simply to say it will take the party's case to be that case set out in the pleadings. That is to say, the amended particulars of claim and the amended defence, I think it is, or re-amended, doesn't really matter. The latest version of the amendments for which leave has been given, and supplemented by, so far as is consistent and does not add anything except by way of particulars, that which is set out in other documents. If parties don't wish to amend to include a new case, so be it. It means that any evidence directed towards a case for which no leave has been given will be disregarded.
The issue we're facing is that we say on that basis, the case which the defendant thinks is consistent with the pleadings, we say that case is a new case.
Right.
So we'll try a different case.
Then if you're right, then their evidence directed towards that case in the end will be pointless for them. If you're wrong, it'll be relevant. And you can turn up at the end of the trial and say that's all very well, but it's not part of your pleaded case. Therefore, it doesn't help you.
But is it not in the interest of the overriding objective best to go to trial on understanding the issues in dispute?
Well, I agree. But since the nub of the matter is, you say, for example, they're introducing a new case on, I think it's one head of loss, for example. They say they're not. Do you want to have, if you want to have a full day application about going through every detail of the pleadings, the history of the pleadings and so on, we can do that. But the alternative way is to say, well, if they insist, if they are confident they're not introducing a new case and don't wish to amend, then they needn't amend. And if they're wrong, they're wrong.
I don't think it would require a full day. It's actually pretty straightforward, I'd suggest.
It can't be that straightforward if both sides.
Just because one side denies what we say is obvious doesn't mean that it's not straightforward, with respect.
I've given my initial view, but anyway, carry on.
I mean, Your Lordship, if you're not minded to hear why we say...
No, I'm happy to hear anything. I'm happy to hear anything. But we have a 2-hour slot, and that's so far away.
I'll just cover 2 of the bases upon which we say there have been changes. The others are set out in the skeleton.
Yeah.
If I could draw Your Lordship to paragraph 32, which is of my skeleton, sorry.
Yeah. Yes.
So the first aspect is the confidential information relied upon. Prior to the trial witness statements, the only pleaded confidential information upon which the defendant sought to rely, it was that allegedly contained in the investor presentations. There's never been any suggestion whatsoever by the defendant that any other type of alleged confidential information was being relied upon. And in fact, one can see that if one goes through the ADC, it's very clear. I mean, for example, if one looks at paragraph 33.1, there's the mention, which we
find. What's the page reference?
AC 139.
Paragraph 33.
And if we look at paragraph 33.1, we can see the reference to investor presentations.
Yeah.
That has been the only type of confidential information which has been mentioned until trial statements came in. Our issue with that was we couldn't understand. We could understand they were saying there was confidential information contained within the investor presentations, not missing that was confidential information, but we didn't know specifically what they were referring to within the presentations and what was the causative link between that and the alleged loss in value. Hence the request. The response to the request, seeking to understand.
Just give me a second so I can just make sure I understand this paragraph. Yeah. Mm-hmm.
If one looks through the entirety of the pleading, there's no mention of any other type of confidential information.
Right.
And then what emerges from the requests and the responses to the requests, and those are set out pursuant to the registrar's order at Annex A of Miss Burt's sixth witness statement. I don't know if your lordship has had the opportunity to skim that.
If you give me a page number.
If we go to AF 2110.
Right.
Actually the table starts on the previous page.
Yeah.
So the requests for further information were made, and the registrar, in light of the deadline for the witness statements, required many of the requests to be responded to by reference to a table.
Yeah.
So, for example, in relation to request 3, which is in fact at 2109.
Yeah.
The particulars were required of each and every allegation of alleged misconduct and how such misconduct caused a loss in value in the business sale. Now, the response refers, and that's in the next column of that table, refers to, among other things, section 5 of the defendant's first witness statement. If we go to that section 5, which is at AF 1128.
AF 1128.
Yeah.
Right.
If we go to paragraph 125, the crux of what we say is the new case on loss is that I now understand that the claimants must have informed GFH that I would be prepared to sell less than 100% of my shares in the company.
Mm-hmm.
And she said, had they not said that, this is her new case, had she not said that, then she would have been able to sell not just the 85% of the shares, but 100% of the shares.
Right.
So that's the new confidential information which forms the basis of the loss of value claim.
Yeah.
If we could switch back to AF 2115.
Mm-hmm.
We've again, the request here was, of the second and third sentence of paragraph 31.1, please provide full and proper particulars of the confidential information referred to therein.
Mm-hmm.
And then the reference there is to paragraph 92 to 105 of the previous witness statement I took you to. I can take you to that. Well, actually, I probably should. AF 1118. We can see that paragraphs 92 to 105 is all about the allegation that allegedly the claimants disclosed that the defendant was prepared to sell less than 100% of her shares.
Mm-hmm.
All of which, when we read these trial witness statements, came as an immense prize.
Mm-hmm.
Now, we can take the next changes together. They're about the loss of value case. The first.
So, this is a change rather than further particularization.
It's the only particulars provided before were in relation to the investor presentations.
Yes.
The reason
that was particulars of a more general allegation, I think. You can remind me of the original paragraph.
The original paragraph refers to confidential information, but in the context of confidential information contained in investor presentations. And this entire...
Can you just give me the page reference again for that one? Sorry.
AC 139.
AC 139. This one turned up again.
And when I go to the next change, the fact that this really is a significant change will be even further emphasised.
Okay.
Sorry, Lordship, have you had the opportunity to read that? So the next set of changes relates to the loss of value case. Pursuant to the pleaded case, the defendant seeks losses in relation to the sale of 85% of the shareholding. That was the amount that was sold pursuant to the SPA. That's what's called the business sale. And we say that she's now dropped that claim, she's now pursuing a new claim, which is a loss of opportunity claim, seeking to claim losses in relation to the sale of an entirely different tranche of shares pursuant to an agreement that wasn't even mentioned in the ADC and that was entered into almost, I believe it was almost 2 years after the entry into the SPA, and it wasn't even entered into with the defendant. And with that new claim, she seeks the sum of 3.56 million. So it's not an insignificant amount that's being counterclaimed pursuant to this new unpleaded case. And to show that this is a new case, if I could take your Lordship to AC 128.
Mm-hmm.
So paragraph 12 here defines business sale, and that definition of business sale is key to how paragraphs, other paragraphs in this plead are interpreted. In essence, the business sale refers to the sale of 85% of the shareholding in date by virtue of a sale purchase agreement dated the 29th of April 2018, the SPA.
Mm-hmm.
So it very clearly relates to 85%. There is no mention anywhere in this pleading of the remaining 15% and any loss of opportunity to sell that at the same time. And nor is there any suggestion that the alleged confidential information is what shareholding the defendant was prepared to sell, as I've already stated before. However, this new case is advanced in the trial witness statements. And again, if we your Lordship may recall that I took you to request 3 of Bert's table. That referred, among other things, to section 5 of Miss Benton's witness statement, which talks about loss of value caused by the claimant's alleged misconduct. Now, if we go to AF 1127, and this is again the section on loss of value allegedly caused by the claimant's conduct. We can see that at paragraphs 120 and 121, the defendant drops her claim for loss of value in the sale of 85% of the shares. So that's the first point. Although I would add that in the witness statements, she tries to have it both ways, and she continues to say, well, I must have lost, there must have been a lost value. I'm just not going to bother putting, or I'm not able to put a figure on it. And instead what she does, if we go on to the next page, which is AF 1128, she introduced this new claim. And if I could invite, I don't know if your lordship's had the chance to read this yet, but paragraphs 122 to the end. It's basically a loss of chance claim. She's saying, but for the breach of confidential information, which she says is this disclosure about selling 100% or not selling 100%, all of the shares would have been bought at once. Then what she does is she puts a very simple, we would say, interesting, has an interesting way of valuing this. She basically proratas the sale price as at the earlier sale, and then looks at the sale later, which was the sale of shares by a completely different company. It wasn't the sale of shares by the defendant. Looks at the difference and says, therefore you claimants owe me 3.56 million. So all in all, that's really a rather different case. Now, in my learned friend skeleton, the case seems to change yet again. She alleges at paragraph 33A on page 10 of her skeleton argument.
Sorry, say it again.
It's paragraph 33A of her skeleton argument. It's page 10 of her skeleton argument.
Yeah.
In summary, she says that the defendant has explained that she has come up with a proxy calculation for her losses using the valuation method in relation to the 15% of shares 2 years later. Now, I'm not sure what a proxy calculation is, but I'd suggest that this is legally and logically nonsensical, if insofar as this is supposed to be a proxy for losses that was suffered in relation, allegedly suffered in relation to the 85% shares. You cannot prove your loss in relation to one tranche of shares by reference to an entirely different tranche of shares sold by a person other than the defendant years later. So, and I think that passage in the skeleton argument of itself illustrates perhaps the difficulties with the defendant's position. So, all in all, a very different case.
Well, I'm not sure whether it's a different case or simply a different way of trying to prove the case, which may or may not be effective.
Well, how could it be a different? Sorry, but if that's, but if using a proxy calculation in relation to a different tranche of shares,
yeah.
Is that supposed to be a proxy? Is the word, perhaps my learned friend can illuminate us on this, is that supposed to be a proxy for losses that was suffered in relation to the 85%? Because that's not what the trial witness statement says. The trial witness statement says, I lost 3.5 million because I couldn't sell that 15% earlier, something which is absolutely not pleaded in the amended defence and counterclaim.
Right.
The amended defence and counterclaim specifically refers to loss of value in the business sale. The business sale is defined by reference to 85% sale pursuant to the SPA.
Yeah.
No mention whatsoever of 15%. And I think it would actually, probably the most basic point here is, if I could take your lordship again back to AC 139.
Yeah, AC 139.
Yeah. Paragraph 33.1.1. The loss of value claim is set out very clearly. Ms. Hennessy and Lal caused a loss of value in the business sale. You then go back to the definition of business sale in paragraph 12. That plainly refers to 85%. No suggestion whatsoever of anything else. And this truly was a huge surprise when we read in the trial witness statements. What appears to have happened is that the defendant realises that she can't prove her losses in relation to the 85%, so has come up with a new case. Now, of course, the defendant can try to put forward a new case, but you can't do so without amending pleadings.
What if it's properly characterized as a new way of demonstrating, which may be legally or evidentially unsatisfactory, but a new way of trying to demonstrate the loss arising from the loss on the loss of value of the business sale? I mean, you may say it's rubbish, but I mean, it's not pleadable.
It's so rubbish that it's beyond laughable.
But if it's beyond laughable, then it's a strikeout application.
But that's not what the trial witness statement says. And to then try and change the case yet again by way of the skeleton argument, this illustrates the problem. What is the case we're going to trial on? There are far too many cases that
which is why I suggested that one solution might be to take a strict view on the pleadings and just go to trial on the pleadings.
But that's exactly what I'm saying, that these are the pleadings. This is what pleadings say.
They're not pleadings if they contain material which goes beyond and contradicts or is not foreshadowed in the main formal pleadings.
Perhaps my learned friend could explain to us what's meant by proxy and how, and if it is supposed to be a proxy for losses in relation to 85%, Where
My Lord, can I just be clear that I'm not pressing my skeleton argument as a pleading? That was intended as a quick summary of why we say it's not a new case, because I don't want to prove that in front of you.
Your lordship's frozen, I'm afraid.
Yes, I can no longer hear you, my lord.
I missed the beginning of what you said, because your microphone was odd.
In case it helps my learned friend, I don't seek to rely on my skeleton argument as a pleading or a definitive statement of the defendant's case. It was intended to be a quick summary of why we say it is not, it's a development of the case that isn't a new case. It's a way of quantifying the case that's pleaded. If my learned friend doesn't like the word proxy, I'll put it a different way in the skeleton argument for trial, but I don't.
Can I just clarify, is it therefore the case that by proxy, you mean a proxy for the loss of value in 85%?
My lord, I will, if it's useful to respond to my learned friend's submissions, I'll do so in full in reply, but I don't think this exchange is going to be useful.
Just give me a second, Carl. My battery's running out. And much as I would love to be cut off. So I'm using someone else's computer. And could you bear with me 5 minutes? Just while I find my daughter whose computer this is.
Not at all, my lord. Can we perhaps take a formal short break and reconvene in 5 minutes? Thank you.
I'll do that. Yes.
So I do think, having seen, it would appear that Miss Hurst is not happy about clarifying what proxy means, if anything, and therefore what the cases we're facing.
I'll hear Miss Hurst.
Just to be practical.
I'll hear Miss Hurst in due course.
Okay. In any event, on the basis that this is an amended case, pursuant to which $3.56 million is counterclaimed in relation to a loss of opportunity to sell the remaining 15% at the same time as the 85%, we say, okay, and also taking into account some of the other amendments that emerge, what are the options? And we're trying to be practical about this. Now, the options would appear to be, if we go to, sorry, my computer has now ceased. Paragraph 5 of my skeleton argument.
Yeah.
What we've proposed are two options. The first option is for permission to rely on Mr. Krishna's fourth witness statement as a statement of case. Before I go into that, need I take your lordship onto the relevant rules of the RDC as to why, if a different case is being pursued, amendments must be made?
No, I accept that.
Thank you.
But that's why I can't quite see why you don't like my suggestion, which proceeds on the basis that if there's a new case developed without leave in witness statements or whatever, then they're not in. And simply they will be ultimately disregarded.
Yes, well, what the only issue is that in my experience, one of the problems with hearings in the DIFC is that one comes to court and issues have not been resolved properly to be determined. And this is exactly what I'm trying to avoid. I want to be able for the parties to go to trial, for the parties and for the court to know exactly what the issues are, rather than wasting time at trial.
The trouble is I can't force even if I thought the defendant was advancing a new case, I couldn't force her to amend. And all I could do was to rule that the new case wasn't part of her case and therefore wouldn't be considered.
Alternatively, our first option that we suggested, and we've suggested it's the most practical one, is to grant us permission to rely on Mr. Krishna's fourth witness statement as a statement of case. Now, Miss Burt's sixth witness statement, which contains the Annex A with the table, that, under the rules of the RDC, constitutes a statement of case. And so there's no reason in principle why why Krishna 4 should not be treated as a statement of case. Krishna 4 addresses the so-called new case, which we're very happy to address. It addresses the new case. It does also, admittedly, introduce estoppel arguments by my clients. And of course, in that respect, we've changed our case. If, though, Krishna 4 is accepted as a statement of case, if an order is given that, in essence, allows any amendment to the defendant's case and the trial witness statements to be allowed, then this would work from a procedural perspective. It's not elegant at all. And let's be frank, none of these statements of case are in the least bit elegant. However, it's a practical way forward in the context of a claim for a few $100,000, which is not a big claim, and which was due to come on to trial very shortly before today, in any event. Now, in that eventuality, if Krishna 4 is treated as a statement of case, then the defendant could be able to file and serve evidence in response to that, which could also stand as a statement of case, and then we would have the opportunity to serve and stand file and serve evidence in reply.
You'll forgive me if I interrupt. I can see what you're trying to do. In some circumstances, it makes sense. We've got 6 weeks until the trial. If we have a sort of rolling pleading with one statement treated as pleadings, then answered by another one, answered by another one, we won't know what the case is about at all until about 2 weeks before the hearing. I'm against pleading by statement as a matter of instinct and habit, I suppose.
Well, it's the first time I've ever suggested it, but when we had the order from the registrar that the responses to the request were going to be put in a witness statement, it was in that context that we tried to come up with this practical solution. Yeah. It feels.
Should I hear Ms. Hurst on this point before we go on to the other point? Ms. Hurst.
Thank you, my lord. I'll try and be brief in response. I've heard what your lordship said, that you're not minded to treat Krishna 4th as a statement of case, so I won't delve into that unless your lordship wants me to.
I'm not actually ruling definitely against it. It's just that it doesn't seem to me to accord with my instincts for getting things a bit clearer.
Well, I'll put that lower down the order then, if I may, and I'll take things in a slightly different order than my skeleton. Although it's possibly useful for your lordship to have that to hand, because I'll go through some of the points there. My lord, you made the suggestion that we could proceed to trial with an order that simply says that the statements of case are the statements of case are the statements of case, and if at trial a party is running an inconsistent case, then that just simply won't be open to them. And you asked my learned friend a number of times why that wasn't a possible solution. I'd venture to suggest that the reason why it's not a possible solution from the claimant's perspective is because that the case that they're running in their witness statements is entirely unpleaded, and that really is the issue. The claimants need to amend and are trying to come up with ever more creative ways of forcing the defendant to amend first. Let me make that point good. My learned friend admitted fairly in her skeleton and in her oral submissions that their statement of case is of poor quality. The consistent refrain has been to blame the claimant's previous legal counsel for that. But it's said that none of this could possibly have been addressed until after the RFI application that they brought in the spring. And in my submission, that simply isn't true.
I said it was much more sensible to amend after the responses to the RFI.
Mr. I didn't interrupt you, and I'd be grateful if I could make...
Ms. Hurst, I'm the ringmaster. Stuart, if you can allow Ms. Hurst to finish. Yes, Ms. Hurst.
Well, you've been taken a number of times, my lord, to paragraph 33 of my client's pleading, the amended defence and counterclaim. I apologise for repetition, but it's probably worth just going there one more time, if I may. It's AC tab 10, and the page is 141. I apologise, 139. Now, it's this, by way of context, it's this paragraph of my client's pleading that was the subject of, by my count, around 41 of the 50-odd RFI requests that were made. And so it's been picked over in some detail in a previous application. And the claimants have had every opportunity to make the complaints that they make. In passing, and just so that we don't have to come back to it, I appreciate I'm going slightly out of order, but just to pick up on my learned friend's point that the only confidential information pleaded is investor presentations, it does say clearly in the second sentence of 33.1 that as part of their intended MBO, Mrs. Hennessy and Lal, that's obviously the claimants, convened meetings with proposed third-party investors and prepared investor presentations, which disclosed highly confidential information. And so I think the case is fairly put that in the course of these meetings and presentations, confidential information was disclosed. Now, I don't need to get into the point because we've done the RFI application, but as I said there, obviously this pleading was prepared at a time prior to disclosure, and the nature of the case is inherently one where the defendant, counterclaimant, didn't have all the details of what was done behind her back. And so the case is put at a general nature, but as in my submission, at a sufficient nature. I don't need to go over that anymore because that was the ground that we covered in the RFI application. But if I can just invite your lordship to sort of scroll down, you can see that paragraph 33, which is the paragraph alleging breach, covers some 4 pages and is a detailed pleading of the various breaches that were alleged against the claimants in the counterclaim. I'm happy to sit with that pleading of breach. The problem for my learned friend is that she has nothing in response. And so if one looks at the reply to this pleading, which is in the statements of case, it's tab, I apologise, I've just lost my reference. It's AC tab 5 and 6. There are 2 replies because this was pre-consolidation of the pleadings, but they are in identical terms, I believe. If one looks at AC 5, my lord, and at paragraph 2.35, which is on page 88. Yep. AC 88. Now, the only pleading in response to that paragraph all of those allegations of breach of confidential information and all of those particulars, the only pleading is paragraph 2.35. Paragraph 33 of the defence is denied. The defendant is put to strict proof of these allegations. That is it. That is the only defence that is advanced, save for, and it's fair to point out, paragraphs 2.7 on page AC 83, if one scrolls back up a little. (2.7, 2.8 and 2.9, my lord, the plea in effect, and I mean no, I hope I'm not inaccurate by summarising, but the plea in effect is that the settlement agreements under which the claimants sue are entirely separate from the employment contracts and all of the other matters that the defendant complains about in the counterclaim. And so even if she establishes those points, they're nothing to the claim, effectively, that the claimants are still entitled to the money under the settlements agreements. That's a short, but I hope fair summary of the case that's put in paragraphs 2.7, 2.8 and 2.9. And that is the only defence to the counterclaim. None, and I really do mean none, of the factual points that are advanced in my learned friend's client's trial witness statements, none of them are pleaded in these documents or any other statements of case, as far as I can see. And that's despite the fact that they run to sort of literal hundreds of pages, I think, of factual responses. I'm not going to take your lordship in detail through their factual evidence and try and show you what is and isn't pleaded, because the short point is that none of it is. But if my lord would look at tab AF, tab 1, just by way of illustration.
Can you give me a page rather than a tab?
Oh, I apologise. It's on page 8. Well, let's look at page AF2. Paragraph 5 of the second claimant's trial witness statement. And these allegations are so extensive as to require a table, but you can see via the table the sort of themes covered in the witness statement. Overview of the individuals and their roles. In fairness, an element of that is pleaded. Abraja's decision to exit date, the defendant's wish to monetize her stake, the claim, David's receipt of the earn-out payment, genesis of the potential MBO, the defendant's case, alleged secret plot, and 8, and this is really the crux of it, my lord, no secret plot. And the claimants, and again, I mean no disrespect by summarising, but the crux of their case, if I can put it that way, is that their attempted MBO was fully disclosed to the defendant in a board meeting in March 2017, that she knew all about the steps that they were taking, and that there was consequently there cannot have been any secret plot because she was well aware of what was going on. That is, if I may put it this way, the basic proposition of the factual defence, which is advanced to the counterclaim. And that proposition is not pleaded anywhere in the claimant's defence to counterclaim or any other statement of case. Now, it's been said that they couldn't possibly have pleaded a proper defence to counterclaim until after the RFIs. And in my submission, that's completely wrong. In the course of the disclosure applications, which we took, well, the application was made in November of last year. On the 14th of December last year, the claimants were required to file affidavits in response to that disclosure application. And in the course of those affidavits, they made, in short, a summary, but effectively the same factual case. One can see that from tab, so AN page 227. I'm afraid I'm using tabs, so I might be slightly slower than your lordship.
I've only just learned how to get straight to a page.
I do need to learn to do that prior to the trial, my lord, and I will note your lordship's comments in that regard. So on page 227, this is the first affidavit of the second claimant again, which was filed in response to the disclosure application. Yeah. If one goes to page 230, at a subheading, the defendant's awareness of the aborted MBO efforts, no secret plot, paragraph 16 onwards. Here we see, in shorter form, albeit, but the same essential factual case being put, that the claimants disclosed their MBO or their proposed or attempted MBO to the defendant in early 2017 at a board meeting, that it was all approved, it was all above board, and that thereafter nothing to see here. That's the essence of the case. And then this affidavit goes on to describe, for example, at paragraph 18, the role of Mr. Atkinson, who's one of the claimant's witnesses for trial. Paragraph 20, discussions with Panmure Gordon. 22, discussions with Mayfair. 24, discussions with GFH. These are all third-party investors that the claimants were discussing an investment, let's put it neutrally, with a potential investment in the business sale. And they're all matters which are mirrored in far more detail, of course, in the trial witness statements, both of the defendant and of the claimants. And so the submission that the claimants couldn't have actually pleaded a case back to the counterclaim until they'd asked all of these very detailed and technical questions of the pleading is wrong. The essence of their claim was well known to them in December, and they just chose not to do anything about the fact that they didn't have anything like a compliant pleading. Now, we then come to the RFI application, and the claimant made their requests, and it's important to highlight, my learned friend accepted, rightly in my submission, that the defendant's response to the RFI application is itself a statement of case. That's accepted. A response to an RFI is a statement of case, albeit the registrar ordered it in the form of a table identifying where those points were raised in the witness statement. It's still verified by a statement of truth, and it might be unorthodox in form, but it was done pursuant to the registrar's order. And so any amendments that came about as a result of responding to the RFI are already in a statement of case. Now, I just pause there to emphasise, at no point during the RFI application was it suggested by the claimants that they would wish to make amendments to their statement of case. No. The entire focus has always been on picking apart small holes in what they perceive to be problems with the defendant's case, without even beginning to acknowledge the problem that they have no factual pleading or real pleading at all in response to the counterclaim. And that the only defence that's advanced in pleadings to the counterclaim is this point that, well, the agreements we sue under are separate, and so who cares effectively about everything that you're saying in the counterclaim? It's not relevant. It's not relevant because you can't bring that in as a defence to payment under the claim. That's the only defence they have in the pleading. And that's why my learned friend doesn't want an order that says, well, let's rely on the pleadings then at trial. And if you're running an inconsistent case in the witness statements, then too bad, because she doesn't have a case in the pleading. So she must amend. And the problem that we have is that the focus has always been on the defendant, trying to force the defendant to amend, making the defendant remedy perceived problems in her case, when all along the claimant doesn't have a pleading at all. And if anyone's going to amend, in my submission, it really has to be the claimant.
Can I just go back to one thing you said, which is that that the response to the RFI is, as a matter of the rules, a pleading. I think you would accept, would you, that insofar as it adds a new claim or a new defence to counterclaim, then it would need leave?
Of course, my lord.
It hasn't got leave. It's not part of your case. I'm talking hypothetically at the moment, rather than focusing on a particular thing.
Of course, my lord. I accept an RFI, to give it its full name, it's a request for further particulars. If they are further particulars of the statement of case, then they stand as the statement of case, no leave required, of course. If the particulars disclose an entirely inconsistent case, then I accept that that would require leave, of course.
Yeah. Thank you.
So
what do you suggest is the solution to, is the answer to the claimant's application?
My lord, I would be quite content with the order that your lordship proposed, which is that we go with the pleadings and nothing but the pleadings. And if your lordship is against me at trial, that I can't prove to you that what is advanced on the evidence is proof of the pleading and not proof of a new claim that's inconsistent with the pleading, then the fact is that my client doesn't make out her counterclaim. It's as simple as that. I don't wish to prove that. But I say it's not appropriate for me to have to prove that now in front of you, because my learned friend hasn't brought a strikeout application. I'm happy to address the points that she's made briefly, as I'm aware we're running out of time. We've got another application to deal with. I'm happy to address them briefly, but I don't have to come to you and prove that my counterclaim works. That's for trial. And the defendant's quite happy to accept that if you're against her on this point on the pleadings, she doesn't make out her case. Yes, if the claimants want to amend, then that's a different matter.
Would you object to an amendment by the claimant? I'm not suggesting they want to amend for the moment. Would you object to an amendment by the claimant, which brings into the pleadings some of the stuff which is presently, you say, not covered by the pleadings, but is there in witness statements and so on?
In principle, my lord, no. We're very shortly out from trial, and it's my own submission that the defendants have run this case in one form or another since December. So I don't seek to say that we're not on notice of what the claimant wants to say. I'm very happy to consider, in the usual way, a draft amended statement of case, and unless there are obvious problems with it, then seek to provide consent in the usual way. That, in my submission, is the far better course, because all these things like the list of issues, etc., that we need to stabilise for trial, they need to be based on the pleadings. They can't be based on some amorphous set of documents that may or may not be pleaded. We need some clarity. My client's position is clear. We're happy to stand by our pleading.
If I was to encourage both parties to make sure their pleadings covered what's in the witness statements, and give it, allow, for example, 2 weeks for that to be done, you wouldn't want to take advantage of that and tidy your pleadings up as well.
My lord, I'll take instructions, but our primary position would be that we're happy to stick with our case. If your lordship indicates that more detail is required, I can see that my learned friend is having some difficulty understanding the case. If it's helpful for us to clarify, then we will clarify.
Well, is there anything else you want to say about this application?
My lord, no, save that. I think your lordship's already indicated an instinct against Krishna fourth. In my submission, it would be entirely irregular for that to stand as the statement of case. It's just not useful in circumstances where it doesn't respond paragraph by paragraph in the way that a responsive pleading does. It's very difficult to sit and pick out what is and isn't a defence to which bits of the amended defence and counterclaim. I won't labour the point because your lordship's given an indication, but if you do want me to address my submissions on Krishna fourth, I will. Otherwise, they're as my skeleton argument, my lord.
Would you like to just clarify one point? As much for Ms. Stewart's benefit as for me, the point about a proxy calculation of damages.
My lord, yes. I'll try not to go back over the documents. Let me just, I apologise, I'm elsewhere in my notes.
It's page 10 of your skeleton.
I'm very grateful. My lord, you were taken through quite a technical submission about what the definition of the business sale is and how it links to the loss of value. I don't want to go through that in detail in the interest of time, but I would note that the definition of the business sale, as my learned friend says, is that it was a sale of 85% of the shares. The case that's advanced in my client's trial witness statement, the way of valuing the loss of value of the shares, well, let's put it this way. The pleading, which you were taken to, but it's set out at paragraph 33b, my skeleton argument. The plea is that the defendant has suffered a loss in an amount to be assessed and the value received for the business sale, since she was not aware that the claimants disclosed confidential information. The definition of business sale is a sale of 85% of the shares. My client says, and it was said, and I think somewhat tendentiously by my learned friend, that the reason this has been done is because she realises she can't make her original claim work, and so here's a new claim. That's not, in my submission, fair in circumstances where the witness statement expressly says that this is being done in the interest of proportionality and to try and avoid the cost of expert evidence. As my learned friend has already pointed out, this is not a huge claim. The sums in dispute on the claim are very small, and the counterclaim somewhat more so, but this is not Rolls-Royce litigation. And in the interest of trying to dispense with the cost of expert evidence, valuation evidence, which we'll come on to in the second application, my client said, well, look, I can easily quantify the value that I have lost via the sale of 85% of the shares, because the claimants disclosed to potential purchasers that I would be willing to accept less than 100. The starting point was a sale of 100% of the shares. Confidential information was disclosed effectively as to the defendant's bottom line. And so she says, that's an easy, I won't use the word proxy because it appears to be causing difficulty, but that's an easy way I can quantify the loss to me that doesn't depend on getting expert evidence of the impact of the disclosures of the other breaches of confidential information on the business sale. And it's relevant, my lord, just to take a step back and, without wanting to get into the details of how the claims and the counterclaim interact, this is a defence to payment under the settlement agreement. And the defence that is alleged is that the claimants were not entitled to those payments if they were in breach of their obligations. I'm summarising because I don't want to spend half an hour going through the pleadings, because I'm not defending a strikeout application. But that's the defence. And so my client's case is if she establishes a breach of one of the obligations that are pleaded at paragraph 33, the claimants were in breach of their obligations to her and to the company, and so they're not entitled to the payments they seek. The quantification element only comes into the counterclaim. So on one level, my lord, I don't even need to go as far as to quantify the counterclaim if I have that first defence to the claim. If we are quantifying the counterclaim, then she says, look, I'm not going to try and quantify the losses that are caused by all of these various disclosures. I'm just going to focus on one because this one's easy. And that way we can get rid of expert evidence because this isn't a massive claim. And that's what's attempted to be done in that section of the defendant's witness statement that my learned friend took you to. Now, she says it's nonsense, and that's entirely her prerogative, and she can argue that at trial. If I'm wrong, if my client's wrong, and that just doesn't work, she can run that at trial, and we can thrash it out there. But in my submission, it's not a new case. It's a calculation of the existing case that was an attempt actually to narrow the problems rather than to widen them, but clearly that doesn't seem to have worked. It's the case we will run, and if we're wrong, we will lose on the counterclaim.
Yes, thank you. Ms. Stewart, briefly, you want to say anything in response?
This is I'm going to be short. This is an entirely new case that they're trying to run. That's evident from the pleadings. It couldn't be more evident. The fact that it is a new case, what happened? If we go to 33.1.1.
Ms. Stewart, this is not a strikeout application. The question is whether, and if you're right about that and there's no amendment, so be it. I'm not going to resolve that now, but do you want to say anything more about the right solution to all this problem? Do you still object to my proposal?
Sorry, could your lordship repeat that proposal?
Simply that I make it clear that any case, sorry, that the pleadings are the pleadings. That is to say, the amended particulars of claim, the amended defence of counterclaim, and the various replies and defence of counterclaims, and that insofar as the witness statements and answers to requests for information simply add particulars of an already pleaded case, that's fine. But if insofar as they raise a new case or a new defence, then they will not be regarded as part of the pleadings. And it's of course without prejudice to the right of either party to apply for leave to amend, to add, to build in or bring into the pleadings things which are presently only in their witness statements. And I would encourage any amendment, if
Yeah.
it's going to be done within a couple of weeks maximum.
On the if I could say that my learned friend mischaracterised the position regarding amendments. We've always been abundantly clear that the statements of case made by drafted by the former legal team were not satisfactory. As soon as the disclosure phase was over, we looked at this and we made the RFIs. That's what would usually happen if you were, and it was, the problem has been that the RFIs, because the application was opposed, the problem is that the responses came only at the time of the witness statements.
We are where we are. Do you want to address my...
But I think it's important to realise that it's a mischaracterisation. And also at the hearing in front of the registrar, actually the issue of amendments was raised. And I agreed with the registrar that we may well want to amend. So I'd like to put up the record.
There's no problem with you amending, I don't suppose, if it's to bring in stuff which is in the witness statements and hasn't so far been incorporated into your pleadings. Yeah. Sorry, I can't speak for your opponents, but I would imagine that people would be sympathetic to an amendment which brought into play formally what is presently in a slightly uncertain status because of in witness statements. But that's what I propose doing, unless you give me a convincing reason not to.
The only thing I would say is that from our perspective, it's unsatisfactory that in that case we would be responding to an amended pleading.
You'll be responding to, you'll be pleading your case.
Right.
If we're going to get hung up on who's responding to whom, then we're never going to get any progress in this case.
Yeah, I mean, it would have been nice to come away from today with an idea of what the genuine issues are in dispute.
You've analysed it already. You have a view as to what is in play and what isn't on the other side.
But there are numerous things that aren't pleaded. But anyway,
well, they're not pleaded. I'm sorry, I don't know if I can say it any more clearly. If they're not pleaded, they're not in play.
Oh, I understand that. We're happy to accept the indication your lordship made in as to the proposed order. We will be putting in an amended pleading, and for the record, we do not accept any of the amendments to the case that have been put forward in the trial statements of the defendant.
Yes. So, but when you get asked to, or if you get asked to accept or consent to an amendment, then that's the time you can either give your consent or refuse it. Very well. Does this need to be part of some order if I say the pleadings are the pleadings, or can parties take it from my indication at this hearing that is a course which I propose to follow at trial?
If we could have an order that we have permission to amend.
You don't have permission until you apply. If you want to apply to amend, you can apply to amend. Hopefully, if it incorporates what's in the witness statements only, then there shouldn't be too much opposition. If there is opposition, then there can be an application.
That was actually part of our application.
You haven't proposed an amendment.
The amendment that we
how can anyone give consent to an amendment when they don't know what it is?
Well, we would say it's clear from HK4, but I hear your point, Your Lordship.
Thank you.
If it assists, my Lord, I think I've already said, but I will repeat. We will, of course, consider and endeavour to give consent to an amended pleading to avoid an application, provided it covers the issues that are already in play. We want to get on with trial preparation as soon as possible. We don't want to come back to court. So we'll do everything we can to avoid that.
Yeah, very well. Thank you. I would just encourage anyone who wants to amend do so as soon as possible, given the timescale, the proximity of the hearing. Thank you. So what order shall I find? I'll make an order which tries to reflect what I've been indicating, and with a short reasons given, which will, I hope, focus parties on what is and what is not in play, not in detail, but in general, in principle.
Thank you, my lord.
Right. Very well. It's your application now. About the witness statement. About the expert evidence.
Yes, I will. I hope that we can perhaps deal with this somewhat quicker. My submissions aren't lengthy. It is hopefully fairly simple. If your lordship could have in front of you the expert report, which is AI1.
AI1.
Yes, my lord. And my skeleton argument alongside it, if that's possible. That's probably the most efficient way.
Yeah. What paragraph your skeleton? What page are on?
We're on bottom of page 14, but really let's start top of page 15, paragraph 38.
Yeah. And just let me. Yeah. Okay.
My lord, it's in my submission rather simple. The principles around expert evidence are pretty self-explanatory, and as per the RDC, I've set them out in my skeleton argument. You obviously have the power to control the evidence. Expert evidence shall be restricted to that which is reasonably required to resolve the proceedings. That's RDC 31.12. Fundamentally, 31.13, no party may call an expert or put in an expert's report without the court's permission. An application, how does that work? Well, an application for permission requires the party to identify the field in which they wish to rely on expert evidence, and then, if practicable, identify the particular expert. That's RDC 31.15. And then under RDC 31.16, if permission is granted, then it is only in relation to the expert named or the field identified by the party under RDC 31.15. So the start and end of it in our submission is, what did the parties ask for, and was permission granted? Because if so, it was only in respect of what the parties asked for. That's how 13, 15 and 16 fit together.
Mm-hmm.
My learned friend has said in her skeleton that, well, the evidence is likely to assist the court, and I just preempt that submission by saying that clearly isn't the test. It would have been the test at the stage of applying for permission to adduce the expert evidence. But what we're concerned with now, the four corners of it is, do they have permission or don't they for this evidence? And so I've set out in paragraph 39 what was asked for. You can see that in the case management sheets, and I'm afraid I've struggled to locate those in the bundle, so I'm just going to go with what's quoted in my skeleton argument. The claimants proposed to study the documents shared by the defendant in relation to good faith calculations and determinations under the agreement, and to quantify the claim of the claimants. So actually, they only asked for expert evidence to quantify their own claim, not the counterclaim. But I don't take a point on that. I'll come on to that in a second. The defendant's proposal, my client's proposal, was for a business valuation expert. The defendant intends to submit an expert report of a business valuation expert who will assess the loss of value in the business sale caused by the claimant's misconduct and breaches. So we are talking about quantum, squarely quantum. The claimants wanted an expert for their own claim, the defendants wanted an expert for their counterclaim. But the relevant point is that neither party sought permission or obtained permission for any expert evidence in relation to what is an MBO, how does an MBO work, what due diligence processes do we go through in an MBO or any investment, how does management typically interact with an MBO? None of that was asked for. We were simply asked for calculations, quantification, valuation, whatever word you want to put on it. I'm going to say quantum broadly to encompass those. And so we get to the CMC, and paragraph 10 of the original CMC order simply records that the parties were granted permission for expert evidence. And it doesn't say, it's fair to point out, it doesn't say the parties are granted permission for expert evidence in relation to quantum. But in my submission, necessarily so, by the way that RDC 31.13, 15 and 16 interact, the only permission that was granted was permission for quantum, because that was the only permission that was asked for. And that's express in RDC 31.16. And for completeness, my lord, the CMC order has been the subject of several amendments. It's been sort of moved around and stretched, but most recently in the Registrar's Order of 30th of May, which is in the bundle. But in relation to this issue, the only point that has ever changed is the date for filing that evidence. It's never been revisited. No party has ever gone back to court and said, we'd like to revisit the scope of permission that has been sought for or obtained.
Case management, July last year, was it?
Yes, my lord, exactly.
Just enough for on us. So I'm just reading the
paragraph 10 of that order, I believe, my lord.
Yeah.
Now, my lord, you've already seen, we've discussed it at some length, so I don't need to go back there, but you've seen that the defendant has since made a decision not to file expert evidence on quantum. Yep. That was the section of the witness statement that you were taken to, on the basis that one can adopt a rather simpler calculation and dispense with the cost. So that witness statement was filed on the 7th of June, and I'm just sort of summarising the exchanges that have happened since then. The defendant then wrote to the claimants pointing this out and saying effectively that they proposed to dispense with expert reports for proportionality and cost saving reasons, i.e. you've seen the way we put our case in the witness statement. We think that we no longer require an expert. On the 14th of June, the claimants rejected that proposal. Now, that's fine. If they want to rely on an expert, that's fine. No part of my submission that we're trying to force them not to have expert evidence just because we've decided not to. But all they said in that correspondence, my lord, was the claimants will be relying upon expert evidence, permission for the same having been given. My lord, I am just, in the interest of time, I'm just taking the correspondence as per my skeleton rather than taking you to the underlying detail of it. I'm just trying to save time, but if you do want to see any of these documents, then please stop me. Again, the defendant responded on the 21st of June saying again that the parties might want to dispense with expert evidence. And if not, the defendant asked the claimants as to the nature and scope of their damages evidence. They asked the claimant, what are the issues that the claimant's damages expert will be addressing as part of their expert report? And can we have a copy of the proposed list of issues that your expert is going to opine on? So that those issues could be the subject of agreement, or that they could see exactly what was proposed to be filed in the interest of transparency. Now, the response was that the claimants said that they were not able to give any detailed consideration to a list of issues until after the reply evidence. But in the course of that correspondence, there was no suggestion that that evidence would cover anything other than quantum. And if my learned friend thinks there is, if she thinks I'm misrepresenting this correspondence in any way, then I'm sure she'll take you to it. The claimants didn't provide a list of issues for their expert, so the questions that are asked in this expert report of Mr. Maxime Girard were not provided to the claimant in advance. Now, I don't suggest that they were obliged to do so, but there was a reasonable request made so that the claimants could understand what was being asked of the expert in advance. And so that if there were any difficulties, such as we now have, that they could have been resolved in advance. It's unfortunate that the claimants didn't cooperate in that regard. But what we now see, my lord, and I apologise, unfortunately, the references in my skeleton are to a different part of the bundle where the expert report is mirrored. But if you've got it in front of you, we can just walk through it. Yeah. Our submission is that when one looks at the questions that have been put to Mr. Girard, and then by obvious extension, the answers to those questions, the vast majority of them have absolutely nothing to do with quantum, and therefore it's not evidence for which the claimants have permission. And so if one looks at AI page 8, if we start there,
yeah,
and we just sort of page turn, if I may, just to make the point good. So starting at 2.2 question A, one sees there the question set out. Sorry if there's a noise disturbance, that's a train going past my window. I hope you can still hear me. Yep. What are the characteristic features of an MBO? Do the proposals referred to in a particular paragraph relate to an MBO? Please provide your reasoning. Now, in my submission, it's fairly obvious. One, the characteristic features of an MBO is plainly not an issue that relates to quantum. It's doubtful, point two, that Mr. Girard is an expert in MBOs or M&A transactions. If I can flick back briefly to paragraph 1.1.2 of his report, which is on page AI3, he explains his expertise, my lord, and it's that I'm a chartered financial analyst and a certified public accountant. I have extensive experience in the quantification of damages in litigation proceedings. It's fair to say that he does say he's prepared valuation reports dealing with fair market value of companies in the context of M&A, as one example, and that he's led financial due diligence experts. What he doesn't say is that he is an experienced advisor or lawyer or expert in M&A transactions or MBOs in particular. And so there is some doubt as to whether he's actually qualified to give this evidence. I don't put it any higher than that. For today's purposes, because my primary submission is that they simply don't have permission. If one goes back to page 8 of the report, I apologise for taking that slightly out of order. Right. We simply have a sort of series of definitions from textbooks about what an MBO is in response to the question, plainly in my submission, not a quantification exercise. And then over the page on page 9, what he's been asked to do is to look at 2 or 3 letters, which are documents disclosing these proceedings, which the defendants rely on as evidence that the MBO was disclosed to the defendant. And they've asked Mr. Girard to comment on them and say, look at this, do you think this is an MBO? Effectively, that's what the question's asking. Again, in my submission, that's plainly nothing to do with calculating the claimant's claim or quantifying the defendant's claim.
And the expert must be allowed to give some context to the focus of their expert evidence.
Right, so, my lord, but the question that's being asked is not a question that provides context for any calculations. He's being asked a quite separate question, which is, how does an MBO work and what do you think about these documents? There's no suggestion in his report that this is necessary background to then come on and do the valuation exercise that he's done. The claimants are simply asking him to comment on evidence that's nothing to do with the valuation exercise that he's being required to do, and they don't have permission for it. Okay. So question B is on page, the sort of bottom half of page 11.
Yeah.
And the question there set out is, assume that management would have rolled over part of their employee share option plan entitlements. In these scenarios, provide your views on the accuracy of a statement in the defendant's witness statement that if management is buying alongside the potential investor in the way of an MBO, then they're aligned with the purchaser in having an incentive to drive down the price of the sale. Now, that's not a quantum question, that's a hypothetical question about the economics or the commerciality of the way that an MBO works. Does a typical investor align with the purchaser or the seller, if I can paraphrase? Again, in my submission, no permission sought for expert evidence as to how an MBO works or what a hypothetical investor would or wouldn't do or who they'd be aligned with. And it's not the function of an expert evidence to an expert witness to comment on paragraphs of the witness statement. That's obviously a matter for cross-examination and for your lordship to take a view of that evidence. Question C. Again, my lord, I'm trying to be quick in the interest of time. I do note the time. And the submission is, I'm afraid, somewhat repetitive. Again, this is a question which asks the expert to look at 3 documents and ask question 1, a purely hypothetical question. about how an MBO works, which is something that one doubts Mr. Gerard has experience to answer. Do the presentations contain the type of information and the level of detail that investors typically expect to receive? Well, that's not an issue in dispute between the parties. It doesn't go to an issue. It's just a hypothetical question. And assuming that the defendant's allegations of misconduct are correct, did they in fact, or would they ever have caused a loss in value? Now, in my submission, the permission given didn't relate to causation. It was a valuation or quantification exercise. But in any event, the question of would they ever have caused any financial loss is, again, a hypothetical question. It's not a valuation question. It's not a valuation exercise that's being done here.
Okay.
Question D.
Which is the one you say is permissible?
Perfectly happy with question G, my lord, which is the question in contrast. If you want to go to that, it's AI 17. This is, in my submission, exactly what permission was sought and obtained for. The defendant quantifies her alleged loss in this way, summarising. Question 1, is the methodology used reasonable? And assuming that, is it possible to determine what loss would have been suffered? Please provide your reasoning. Now, that's a quantum question. That's saying, look what the defendant's done. Do you agree with that? Is the methodology right? Yes or no? Is this an appropriate way to value the claim? Yes or no? No difficulty with that whatsoever. And what's clear, my lord, is if one looks at this answer, it's entirely self-contained, and one doesn't need to have background about what is an MBO, what isn't an MBO, what are these other bits of evidence say, you know, what do you think about this or that? Because it doesn't relate to the actual quantification of the claim and what's being asked to be done here. It's simply a valuation exercise. It's asking, you've seen what the defendant's done. Do you agree with it? And if not, why not?
Is F in the same category?
I'm so sorry, my lord, I've scrolled in the wrong direction. One second.
It's not so much asking about figures, but it's asking about the factor which might affect price.
My lord, I would accept that this is, my submission is borderline. I would say that it's the wrong side of the line because it's, again, hypothetical. How, if at all, would this have impacted the attractiveness of the proposed sale? The attractiveness of the proposed sale is not a valuation exercise. The share price achieved, I would accept that if what's being asked is in this particular case, and that is the way that in fairness, the report has been, the question has been interpreted. In this particular case, did it impact the share sale? I'd be prepared to accept that is a valuation question. But the hypothetical, in my submission, is not a useful question. One can see that from the answer that's given at paragraph 2.7.3, which is, I can't answer this question because it's hypothetical, effectively.
Okay.
My lord, you have the submissions in writing. I will go through each of the sections we seek to strike out if your lordship wishes me to. I realise we've taken them slightly out of order. I'm sorry, my lord, I didn't. Did you see that?
I've got the point, I think.
Thank you, my lord. And I think if I can sort of summarise and tie them together, there are 4 points that are common to some or all of the questions. Either they ask the expert to opine on various corporate features of what is an MBO, or how does a typical M&A MBO transaction typically work. That's not something for which permission was obtained. It's in any event hypothetical and not reasonably limited to evidence that would assist the court in resolving the dispute. And there is some doubt as to whether Mr. Gerard is actually qualified to answer those questions. Just to finish my submissions, my lord, two or three more minutes. We do say that it's unfortunate that this has happened in this way when we did specifically try and engage with the claimants about what evidence they were going to be filing. And had the claimant said, look, we've come up with all these questions, which to us appear to now be ways of dealing with points that are raised in reply evidence. Had they come to us and said, this is what we're proposing, we could have discussed it. One, as to whether the scope of permission for expert evidence needed to be expanded, but also, as you've seen, the defendant had taken a sensible and proportionate decision not to file expert evidence on quantum because she didn't think it was necessary, and is now faced with a report that goes much wider than issues of quantum, and she has had no opportunity to put in her own evidence on these points. So we do say it's prejudicial to the defendant for the claimants to have proceeded in this manner. And I would pray in aid, if I may, the fact that, as your lordship has already indicated, the time we have available for trial is extremely tight. I can, of course, cross-examine Mr. Girard about why I say some of these things are entirely irrelevant. But in my submission, that's time that we don't need to allow for if your lordship takes control of the evidence, as you're entitled to do, and simply disregard that for which permission wasn't given. And so in my submission, that's the more appropriate and proportionate order, given where we are. My lord, unless I can assist further, those are my submissions on the application.
Thank you, Ms. Stewart.
The reason the defendant is seeking to strike out this evidence is because it supports strongly the claimant's case, and not for any of, and there is no basis for striking this out. If we go to, for example, first of all, there's nothing in the orders that actually sets out what the scope of the evidence, what the field of expertise should be. However,
about 31.16 and 15 and 16 of the rules.
Oh no, but what I'm saying, I was just going to go on to the case information sheets.
Right.
That, what the defendant sought evidence for was a business valuation expert. The defendant intends to submit an expert report of a business valuation expert who will assess the loss of value in the business sale caused by the claimant's misconduct and breaches. Each and every one of those questions goes to the allegations of misconduct and is relevant to the link between misconduct and alleged loss.
Can you give me a page number for that, please?
Sorry, for the case information sheet?
The bit you just read.
Yes. I think it is. Sorry. I think it's AJ 13. Is that? So that's the. In fact, if we go to the defendants.
Management information sheet.
Yeah, case management.
As the claimants.
Sorry, AJ 18.
Yeah. Paragraph.
Paragraph 12, that's an actual fact on AJ 20.
Yes, assess the loss of value.
Yes, as pleaded, the case makes a number of allegations of misconduct as further particularised in the defendant's witness statements.
You didn't ask to call expert evidence about whether such conduct was misconduct.
But it's still causative as regards. Surely it's still a question of causation as to whether it caused loss. For example, there are allegations that we went behind the defendant's back to seek to negotiate our share incentives post-acquisition, we've sought expert evidence as to whether that would be common practice, that kind of thing.
What your application says.
Sorry?
The bit you read from the case management information sheet, whatever it's called, was seeking an expert report to assess the loss of value in the sale caused by various misconduct and breaches, not to go into the question of whether the conduct was misconduct or whether the conduct amounted to a breach of some duty. You're looking at the loss of value.
Yes, but it's surely relevant to, for example, one of the questions is, a lot is written in the witness evidence about, had we known, it's alleged by the defendants, had we known about this, we would have cut out senior management from the due diligence exercise. Had that happened, had they not been involved in the due diligence exercise, it's the implication, we would not have suffered loss. Now, therefore, the question arises as to whether it's common practice to cut out, even if there was a known MBO situation and a conflict of, an alleged conflict of interest, whether they would typically be cut out of the due diligence process.
That's not a question on loss. The loss question is whether if they were cut out or if they weren't, what the difference would be in value.
Yes, but what we're
not whether they should have been cut out or shouldn't.
No, but what we're saying is that it never would have happened, that they would have been cut out. So in either situation, there is no causal link.
That's not for an expert on loss to deal with. It's for other evidence to deal with.
Well, insofar as it's common practice, and it goes to the question of what's required in the course of due diligence in these types.
Yes, that's not what you asked the expert witness for, to talk about what's required in the course of due diligence. You're asking about loss.
In fact, if one looks at the way that the expert report, the questions are asked, we've actually asked him to assume that there was, in essence, to assume there was misconduct, and we are looking at that causal connection. And our position is that permission was given for causation, and that these are matters, how these types of sales are actually executed, what happens, so on and so forth. These
well, that's not what you've got leave for.
If we go to, if I could take your lordship to the case of if I could take your lordship to the case of Hoyle and Rogers.
Yeah.
And I gave the extract in my skeleton argument.
Yeah.
And in essence, that's saying that.
Remind me of the page.
I'm sorry?
Remind me of the page.
Oh, sorry, 54 of my skeleton argument.
No, page of the case.
AD 59.
No. Sorry, the page number in the report.
I'll have to find it. It's actually on the system.
Yes, I've got it. I downloaded it because I was reading it somewhere else.
Oh.
Okay, I'll take it from your skeleton then.
It really does just say that.
My lord, I think it's A059. Perhaps my friend has a manuscript note and the O looks like a D. I think it's A059.
say 059, but in terms of if your lordship, it's page 292.
Thank you. Yeah. Okay. Right.
And then if we go back, so that just quotes, that's just the paragraph that's in my skeleton argument.
So remind me which, I've got 25.
11, so it's paragraph 117.
Oh, yeah, okay. Yeah. The problem with that is that's dealing with a case where the expert is focusing on the proper matters and adds bits which are not really a matter of expertise, and the court says basically just ignore them. This is the other way around. But if your opponent is right, then the expert report only touches upon briefly in one or two paragraphs the subject matter of loss, and the rest of it is irrelevant.
And if we could go to now to the decision in Kennedy and Cordier. I don't know if your lordships had the opportunity.
I'm familiar with it. Yeah.
You're familiar with it, and so
just give me the quote from the passage from your skeleton.
in fact, if I could draw your lordship's attention from paragraph 40.
40 of your skeleton.
Yeah. No, sorry, paragraph 40 of the Kennedy case.
Right. Yeah.
So this
yes.
And here, and I accept I do accept your lordship the point about permission and what the scope of the permission was, which I'll touch on if I could just go to these points first. 40. Experts can and often do give evidence as fact as well as opinion evidence.
Yeah, I've read that.
Yeah. Paragraph 41, I'm assuming that your lordship's familiar with.
Yep.
There are many examples of skilled witnesses giving evidence of fact of that nature.
That's all factual matters relevant to the point by which they're being called on. Their expertise is being
Yes.
called in.
The short point is that we looked at the case management order, and it didn't say anything about in that case management order about the field of expertise or the scope. Yeah. Now, perhaps that was our mistake, perhaps in going too far. If it's what we would say is that all of the points in the expert report directly and squarely address issues which are covered at length in the witness statement. And if it is the case that your lordship finds that permission was not granted for these points, despite the silence in the order, and we were not instructed at the time that this was made, we don't have transcripts of the hearing, we simply don't know what happened. So
you need the hearing. Your case management information sheet tells you what you asked for.
But we don't know what was actually decided at the. One would usually expect to have field of expertise and the.
What's decided is in the order read with the rules.
So if it's on the basis that we have gone beyond what was permitted, then we would seek, in any event, to be able to rely on this expert report. We believe we'll be prejudiced in not being able to rely on these points, because they really do squarely go to the main allegations.
Right. The point is, you've delivered an expert report which goes beyond what was sought and granted. It was meant to be delivered originally, I think, quite early in the year. It's now July. I can't remember what the date of the case management order was. But anyway, but it's now July, end of July, with a hearing due to commence mid-September. And on matters, your expert report covers matters which the other party have not had an opportunity of dealing with, and would take quite a long time if they wanted to get an expert to deal with. We haven't discussed proportionality or anything.
Well, it didn't take our expert longer than a few days to deal with it. So
it wouldn't take her long then to revise a report and limit it to what she's allowed to limit it to. And if it didn't take her long, why was it so late in being produced?
Because it had to come after the reply statements. Right. So, and the reply statements were delayed by the RFI application, and there was a long delay in actually having the hearing of the RFI application. The order for that only came out in...
Why was there a need to delay the expert evidence till after that?
To see, well, first of all, to get the clarity on what the case was. It goes without saying. And secondly, I'd submit that it's entirely normal for the expert report to provide his report after the closing of evidence.
Right.
So that he knows, so that the correct questions can be asked.
And you might have cooperated with the other side in identifying the questions.
Well,
was there a reason for
that?
But
there are many things I could say to that, but anyway.
If they're relevant, say so. If they're not, don't.
If it's the case that my learned friend would like to, I mean, ideally we would submit that we should be able to rely on this expert report. There are many points in here which are directly relevant to the issues in dispute. The extensive allegations, including, really quite detailed allegations that have been brought up in the trial witness statements. We believe it would assist the court, and
well, that may be, but that's a different argument. The present thing is you've got leave for one thing and you've put in another.
The other way of considering it is that because there is actually no field of expertise named in the order, in the case management order, it could be said that it's been left very broad, namely that it's quite simply a business valuation expert.
Not if we read the case management order in the context of the rules. But what I'm going to do, rather than do some sort of judicial exercise and going through paragraph by paragraph and cutting out, I will extend your time for lodging an expert report on loss or quantum. It won't take your expert long, you say, by 10 days, and you can lodge a report complying with the order within that time. And the present report is I'm not sure what the technical thing is not admitted in evidence.
And perhaps some indication if we were to apply for permission to rely on numerous technical points that have in fact been brought up in the defendant's witness statements? Would we be of the type that have been answered?
I will consider any application if it's properly made and formulated. I'm not going to give an indication as to the outcome of an application, which I don't know what it would be yet.
Thank you.
So I hope that's clear that I am not allowing Ms. Girard's expert report to be, it probably has been filed. I don't know quite how I unfile it. I expect there's a way. But Hamid will tell me the proper order.
How about to be treated as not filed?
Okay.
Served.
Okay, so I will make an order that Ms. Girard's expert report is treated as not filed in process. I will allow, I'll extend the time for lodging an expert report on, you're going to say on quantum, is that the best word to describe what's allowed? On quantum within 10 days from today. So I didn't ask you about timing.
Could it be causation and quantum? Just to clarify, no. It also covers causation, which was in the wording of
quantum. The focus is on quantum. As I read your case management application, focuses on quantum or loss.
My lord, can I just ask a couple of points by way of clarification, just to assist us in responding? Is your lordship's envisaging effectively that the claimants just delete the bits that don't correspond with the scope of the order, or is your lordship granting them permission to have another go on the bits that do correspond? Because that does have a cost implication for us.
Anticipating that the defendants the claimant would pay the cost of this part of the application, including any consequential costs. Because I think the problem is if we try and amend or prune the existing statement, it would be a much more costly exercise than simply discarding it and putting something in dealing with loss.
My concern, my lord, is simply that we've had to look at this and deal with this report. And in my submission, you can simply delete everything that isn't paragraphs 2F and 2G, or sections 2F and 2G, well, and that is easier and quicker than the claimants effectively having another go.
Is the problem not that some bits of the other paragraphs may be relevant to be incorporated by way of context? I'm not saying all of it or much of it, but
I wouldn't necessarily accept that, my lord, but I take the point and I don't press the submission further.
I'm sorry, it's going to be any order I make will be disproportionately costly, I think, in this, and I don't want to have further arguments about what extra the witness is allowed to put in. But I think if I give 10 days to allow the claimant to submit an expert report limited to issues of quantum or loss, I think that's probably the best way of expressing it. And within 10 days from today.
Thank you, my lord.
This is therefore a directly relevant point is whether this valuation approach that comes up with 3.5 million is a proxy for the loss of value of 85%.
Your expert can deal with all aspects or to do with quantum or loss.
So,
if your expert wants to say that's a very good idea, here are my thoughts on it, fine. If she wants to say that's a rubbish idea because it doesn't give you any indication of the loss for the 85%, that's again for her to say. But I'm not going to tie her hands.
I meant more in relation to if we're going back to the issue about the 85% and that it's a proxy for the loss in relation to 85%, i.e. that the 85% of the shares would have been sold for a higher amount, which is what the alternative argument is, but which they haven't sought to quantify. That then goes to all of these other misconduct points, and whether that misconduct, if we assume the misconduct, which of course we deny, but if we assume it, would have caused any loss, and therefore whether any quantum arises. Therefore, we have to go through each and every point of the misconduct that's alleged, as has been touched on, more than touched on, in the existing report.
I've given you my ruling. It doesn't seem to me that it involves your expert giving any views as to the nature and obligations incumbent on parties to a management buyout or any of that sort.
But if the question I'm asking is, if we're going back, and I'm sorry, Ms. Hurst finds this difficult, but if we're going back to the existing pleaded case, the question is not just it has nothing to do, we say, with alleged breach of confidentiality in relation to what proportion of shares would be sold. It relates to all these other points that are brought up in, for example, the defendant's first witness statement, which I think is some 40 pages, of one alleged misconduct after the next, which allegedly resulted in loss, the proxy for which is now being this methodology which came up with 3.5 million. I don't know, it's just a much, and I just don't want us to be criticised if we actually ask questions like, if you assume this misconduct, would this have resulted in any loss? Does the allegation at paragraph X of the defendant's witness statement, which says that this particular alleged misconduct did lead to loss, what is your view on that? Would we be criticised for that?
I wouldn't have thought so. If you're asking if the question is focused on whether it caused loss or whatever else I said, whether it caused loss or such conduct could cause loss, then that's within the remit.
Thank you. Thank you. That's all. That was what I was trying to get to before. Yeah.
Very well. What I'm going to do, though, I'm afraid, sorry, I'll say I'm afraid, I'm just trying to temper my ruling. I'm going to order the costs of the expert application point be paid by the claimants, including costs of dealing with the original expert report. Now, what about dates? Have you had instructions?
My lord, I'll just need a quick moment to check that. If I can just mute myself and.
If you both you check.
Yes, I'll just mute myself too.
My lord, I have availability for the legal team, but we are struggling to get hold of the defendant. Can I ask for 2 more minutes to just try calling her one more time?
Of course, I've forgotten what dates we're looking at.
You said the week commencing 7th of November or 14th of November, my lord.
Yeah. Just before you take time doing that, I think just ask Miss Stewart what her client's position is.
Both those weeks are fine.
Both those weeks. And would you propose that we have all 4 days at one, or 3 to 4 days at once, or do you want to keep the September dates and just add on a day or two?
I personally think it would be more cost effective to do all of the dates at once.
Yeah. Ms. Hurst, is that what you're looking for instructions on as well? Doing the whole 4
Yes,
days?
I agree with Ms. Stewart that it's likely to be more cost effective, and that is a concern for us. So let's go with all together. I can tell you, my lord, that there's a clash within the legal team on the week commencing the 7th, so the 14th is preferable. My instructed solicitors are trying to get hold of the defendant. My suggestion would be perhaps we list with liberty to apply if it's a huge problem, but we will move heaven and earth to get her there if we do move and list it then.
But I'm sure that it's far enough ahead that any engagements you may have at the moment can be rearranged.
Yes, I'm sure of that, my lord. I just don't have explicit instructions that she is available, but we will, I'm sure, be able to make it work.
Very well. I will, if you're both content with this, we'll have. Should we make it 4 days rather than 3? And then you can, if you've finished the evidence in the middle of day 3, you can then break and have half a day each on the 4th day for submissions. Would that be sensible rather than try and cram submissions into half an hour each at the end of the 3rd day?
That would be preferable.
Ms. Hurst, do you agree with that?
My lord, yes. I'm somewhat reluctant to add a 4th day because we are concerned about increasing costs, but I do accept that the timetable is very stretched as it stands, and I can see the sense in having the 4th day available if required.
Certainly my experience recently of estimates means that they run to the wire, and it's better to have the opportunity of a little bit extra. But, and we can fix it for, what we could do is fix it for 14th, 15th, 16th, with the possibility of 17th as a runoff day, as an extra day if required.
I think that's sensible, my lord. And once we have the list of issues set forth and so on, we can liaise on the timetable and see whether we think we need to go into the 4th day.
Thank you. And when you're, I mean, the point made by one of you, and I can't remember which one it was, said that the timing for witnesses didn't really allow for examination in chief, re-examination, and so on, which is right. But there's always a time lost between witnesses too. So, you know, by the time you've got some re-examination, you might be adding up, and general time loss, you might be adding up to half an hour per witness. So just bear that in mind.
Well, I think it was unfortunate terminology on my part that I had intended to just indicate a general block for that witness's evidence, the majority of which would be cross-examination. But the point is taken. Obviously, we need time for examination in chief and re-exam.
And it shouldn't be much in chief because they go by reference to their statements. But
I hope not.
yes, quite. Good. Okay. Well, we'll fix it for 14th, 15th, 16th November, with 17th kept free as an overspill for overrunning if necessary. All right.
Just one outstanding matter in relation to we're ordered to pay the costs of the expert report. Yeah. And otherwise it's costs in the case for today.
That's what I would suggest.
My lord, I would make an application for my cost of the pleadings application, if I can put it that way as well, on the basis that the entire application in my submission wouldn't have been necessary if the claimants had simply applied to amend their case as they now seem to wish to do. We've gone round the houses and considering Krishna Fourth and so on, and ended up in a completely different place than we started. I would ask for my costs of that exercise.
Well, I think it is part of the function of a PTR to resolve issues, and I think this falls just the side of the line that falls within the PTR's natural competence. So what I'm proposed to do is order that the claimants pay the costs of an occasion by the service, by the expert evidence served on whatever date it was, and otherwise costs in the case.
Thank you, my lord.
That's the question.
There are one or two dates that we have in the case management order for filing bundles and skeletons and so forth. Can we just take it that those will be the same period of time in advance of the trial as relisted? We don't need to, we can add those into the order.
Happy with that, Ms. Stewart?
Makes complete sense.
I would encourage you to make it slightly earlier if you can. But why do you both agree some dates which reflect the same sort of timescale? If you can bring it forward by a few days, it always helps in case you slip.
Thank you, my lord. And your lordship has indicated that you'll give brief reasons on the expert application, but otherwise, is it useful for us to prepare a revised, effectively case management order with the dates and so forth? Sorry, my lord, I've lost you. I don't know if it's just me.
I lost you completely for about a minute.
I'm sorry. I was merely offering, is it helpful for us to produce a draft order that deals with the procedural aspects of today, i.e. the shifting dates and so forth in the case management order?
It probably would be, if you agree, Ms. Stewart.
Yeah, absolutely. Well, we need a meeting, don't we? So
you can email the registry. And Hamid, is Hamid there? Or Maitha?
Yes, it's Maitha here.
Maitha.
Yes.
The parties will email consequential suggested dates for complying with things like the documentary evidence and so on. Is that all right?
Yes.
And if you prepare a draft order reflecting what we've decided, and I'll add some reasons and maybe fiddle around with the wording of the order to reflect what I've intended to say.
Certainly, Your Honor, we'll do that.
Thank you very much. Well, thank you both very much. Look forward to seeing you in November.
Thank you.
We'll discharge the September dates, obviously.
I'm grateful.
Thank you.